Hello, everyone, and thank you for joining us for this afternoon's webinar, Federal Advocacy After the Obamacare Decision. My name is Christopher DeRocher. I'm the Government Affairs Counsel for the Constitution Project. Last year, after the Supreme Court's decision regarding the Affordable Care Act, more commonly referred to as Obamacare, the Constitution Project was concerned that the Court's discussion of three major issues, the Commerce Clause, the taxing power, and the spending power, could affect our ability and the ability of other organizations advocating on a variety of issues to successfully advocate for the creation or continuation of federal programs that promote national policy. Perhaps more importantly, we were concerned that misunderstandings or overly broad applications of the Court's decision by policymakers could make it more difficult to convince them to adopt proposed policy reforms. So we thought that getting some answers and explanations from one of the country's leading experts on the issue would be helpful to us and to others who seek policy reform at the federal level. We turned to Robert Weiner, a partner at the law firm of Arnold Porter. Rob, along with Arnold Porter attorneys Alan Veronic and Julian Waldo, drafted a memorandum which we circulated broadly to organizations that advocate on a variety of issues. A link to that memorandum was provided on this webinar invitation, and it's also available on the Constitution Project's website. We also circulated the memorandum widely to Congress to help members and their staff understand the decision and its impact. Today, we're fortunate enough to have Rob with us to explain the Court's ruling and answer questions about the impact of the decision and how best to tailor future approaches to ensure that they meet constitutional muster. As I mentioned, Rob is a partner at the law firm of Arnold Porter. From 2010 to 2012, he served as Associate Deputy Attorney General at the United States Department of Justice. While at the DOJ, among his many responsibilities, Rob oversaw the defense of the new health care law from the outset of litigation through the arguments at the Supreme Court. Rob has also served as White House Senior Counsel during the Clinton administration. Rob, thank you so much for taking the time to speak with us today.
Thank you. It's a pleasure to talk with you. And it was a great privilege to be able to work on the healthcare litigation. It was one of a kind. The public awareness of the case was extraordinary. It was really higher than any case except Bush versus Gore, and the partisan fires surrounding it obscured legal distinctions and a lot of the limitations that the government built into its arguments. But despite the hype, the legal ruling upholding the individual mandate, while it was critical to the fate of healthcare reform, may not over time have any dramatic impact on the evolution of constitutional law, and the opinion both on the mandate and on Medicaid really shouldn't impede advocates of new social or economic legislation. But, and there's always a but, the forces that fueled this litigation, the partisan pressures that took an off-the-wall legal theory and put it on the wall, those pressures persist. And they do pose a significant challenge to legislative and regulatory initiatives. So the NFIB opinion, the opinion in the healthcare case, is not in itself problematic, but it does provide a talking point or a weapon for opponents of these initiatives, and it is prudent to consider responsive strategies. So I'm going to do three things in the time we have together today. First, I'm going to briefly describe what the court held in the NFIB case. Second, I'm going to discuss the legal impact of that holding and the appropriate response of advocates to inflated interpretations of the case. And then third, I'm going to discuss how to shape proposed legislation and regulations to parry these potential attacks. And then if I will address questions that come through on the chat line. So let's start with the description of the case. There are a lot of challenges to the Affordable Care Act in the lower courts. Case that came before the Supreme Court involved state governments, and it presented two issues: whether Congress could require individuals to obtain health insurance or pay a penalty, and whether Congress could require state governments to participate in the expansion of Medicaid under the Act, which the federal government paid for almost entirely, at the risk of losing Medicaid funding. Now, interestingly, nearly everyone, including many of the plaintiffs, thought the second point, the Medicaid point, was essentially a throwaway in the case to shore up the state's standing on the first question, the mandate, but it turned out to have more significance. 3 days of argument in the Supreme Court. The result was a highly fragmented opinion. Let me give you the scorecard. 5 justices, including the Chief Justice, the author of the majority, ruled that the mandate was constitutional under the taxing power, that is, the individual mandate. The court noted that the provision appears in the Internal Revenue Code, calculated as a percentage of income collected by the IRS, cannot exceed the cost of complying with the mandate, and does not require scienter, among other things. The Chief Justice, in a portion of his opinion joined by no one else, also found that the mandate oversteps Congress's authority under the Commerce Clause because it requires people to enter commerce rather than regulating existing commerce. 4 dissenting justices agreed with that, saying that the mandate was unconstitutional because it went beyond commerce power. Then 7 justices agreed that the expansion of Medicaid to individuals and families with incomes below 133% of the federal poverty level was unconstitutional because it put states at risk of losing their current Medicaid funding if they did not participate in the expansion of Medicaid under the Affordable Care Act. 5 of those 7 found that prohibiting HHS from cutting off existing Medicaid funding was sufficient to solve the problem, and that Congress could impose conditions on the new Medicaid money, but not on the existing funds. 4 justices would have struck down the entire statute, from abstinence education to private rooms for nursing mothers in the workplace, to closing the donut hole for Medicare. So this was sort of a Rubik's Cube of Supreme Court decision making, but there is a holding, and the holding is that the statute is constitutional under the taxing power, and the second holding is that the Medicaid expansion is legal, but HHS can't threaten existing programs if states don't participate. Those were the 2 holdings. Those were the only 2 holdings. Now, that said, it doesn't take a math genius to figure out that the Chief Justice saying the mandate violates the Commerce Clause plus 4 dissenting justices saying the same thing equals 5, which is a majority. But legally, and this issue is controversial, but legally you don't mix and match votes from separate opinions to get a precedential ruling when there is already a majority on a dispositive ground. In other words, the Commerce Clause ruling is not legally binding. Well, that's all well and good, Mr. Weiner, the judge says, but the folks on the Supreme Court review my decisions, and 5 of them think the mandate's unconstitutional under the Commerce Clause. Well, yeah, I'm not saying that you should pull on Superman's cape here, or more aptly on the Chief Justice's robes. My point is not that advocates should propose legislation with new mandates expressly predicated on the commerce power. My only point is that the absence of a binding precedent accords advocates some flexibility and accords lower courts some flexibility, and importantly, it gives them, or at least some of them, an incentive to avoid the issue, the Commerce Clause issue. And that incentive is important because the opinion also provides a roadmap under the taxing power as to how to draft a constitutional statute, how to defend it, and how to uphold it. The legal indeterminacy of the decision on the Commerce Clause might also be important if, as may be the case, the split on the mandate issue reflects the influence of partisan passions regarding this legislation, and more generally, the ACA passed on a purely partisan vote. All the states opposing the act in the case had Republican leadership. In fact, some joined only after elections in which the leadership changed from Democratic to Republican. 43 Republican senators, citing their oath to uphold the Constitution, filed an amicus brief attacking the constitutionality of the mandate, even though 10 of them had previously sponsored legislation with just such a provision. The unconstitutional constitutionality of the mandate became political orthodoxy on one side of the aisle, which accounted in part for the dramatic rise in its credibility. And the flip side is that there was near unanimity on the Democratic side on the constitutionality of the mandate. But the importance of this partisan origin is that today's partisan divide, and in particular its focus on this particular legislation, is not set in stone. And as those passions subside, hopefully, the fact that there's no binding precedent on this issue could well turn out to be significant. But let me emphasize an important caveat here. 4 justices were prepared to strike down the entire statute, and I can't overstate what chaos that would have produced with regard to all the programs that were already in effect, changes to Medicare reimbursements, 100 million transactions a month. The computers had been reprogrammed. Some of those reimbursements were higher under the Act, which the government might have had to recoup. Some were lower, which might have prompted hospitals to sue. There were adult children already on their parents' insurance policies. There were tax credits already given. There were anti-fraud provisions already being enforced. Grants already had been dispersed. To argue that all 2,700 pages of the statute should fall was a radical and somewhat shocking position. And if that extreme position signals a new anti-regulatory zealotry that has galvanized at least 4 members of the court, with the Chief Justice as the swing vote, then a lot of existing and proposed legislation would be at risk. So we've talked about the opinion then and what its potential impact might be, and why, what the arguments are as to why that impact legally is limited. Let's turn to some of the rules of the road for legislative advocates. The opinions of the 5 justices who would have struck down the statute under the Commerce Clause provide some hints on how to avoid constitutional problems. Many of these are spelled out in our paper, but here are some of the key ones. First, the justices repeatedly emphasized the novelty of the mandate. This was the first of its kind. It had never been done before, at least under the Commerce power. So that suggests that no existing bills should have this constitutional problem. And so, to the extent you can model legislative proposals on existing law, treat them as incremental extensions of existing law, you insulate proposed legislation from constitutional attack. Second, a principle problem here that the government confronted in defending the statute was that the statute articulated the individual mandate as a command. It said individuals are required to have insurance, and then in a separate subsection it said that if they don't get insurance, they pay the penalty. Now, the economic psychologists or the psychological economists, I'm not sure which, they might tell you that this formulation yields better compliance. But if it's at all possible, it's better, at least from the perspective of legal survivability, to say a formulation, for example, anyone who does not have insurance must pay a certain amount of money. There are a lot of statutory analogies for that. Now, 5 justices did uphold the mandate under the taxing power, and the majority opinion provides guidance as to how to draft legislation that can be upheld on that ground. Now, I always thought the taxing argument was right, but the biggest hurdle we faced in advancing it was that Congress didn't use the word tax. There is a strong case, of course, which the court accepted, that this doesn't matter, but the absence of the word tax in the provision was still a pretty formidable obstacle. So if you take the tack in proposing legislation that the enforcement mechanism is a tax, call it a tax, or expressly invoke the taxing power, unless the politics are so toxic that it is just impossible. The court also, as noted, set forth a few indicia of the, lack of a better word, taxness of the provision, and these too provide some legislative guideposts. The enforcement provision here was in the Internal Revenue Code, so that's where you should put an enforcement provision. The IRS collected it. They're pretty good at that, and you might want to do that as well. The provision here didn't require cyanar, so don't require cyanar. The provision didn't look punitive. Don't use punitive language. Don't make the penalty disproportionate. And this penalty produced revenue. Make sure that you submit legislative history or work with the Joint Committee on Taxation to quantify how much revenue the penalty provision or the tax here would produce. And remember that the Chief Justice did not say that legislation based on the taxing power was off scot-free. If the penalty is too large, even if you invoke the taxing power, if it's too punitive, the court might well not sustain it. So let's turn to Medicaid, that part of the decision, which is quite significant. Or perhaps it is not quite significant. It might be sui generis, might be something you don't need to worry about, because the court emphasized repeatedly how huge a slice of the state budgets Medicaid takes, and how dramatic an expansion of Medicaid the ACA had mandated. Now, it could be that smaller programs are off the hook. But again, prudence is warranted. I think you can make the argument about the sui generis nature of the holding in that case when you're dealing with other legislative provisions. But it is still prudent to plumb the opinion for the types of measures that would make it more likely that if the opinion is not sui generis, the provisions would be upheld under the principles that the NFIB opinion sets forth. Now, the court made clear that when Congress provides funding to the states, it's entitled to say how that money is to be spent. A state can refuse the money, but if the state doesn't refuse it, if it accepts the money, then it must comply with the unambiguous conditions Congress imposes. Now, in NFIB, the court found it improperly coercive for the ACA to require the states to participate in a new program or else lose the funding that they already have for existing programs. So how do you tell the difference between a new program and a modification of an old program? Because after all, here what you had was called an expansion of Medicaid, which is an existing program. It had the same administrative superstructure, served the same general purpose. So what's the dividing line? And there really is no intellectually satisfying answer to that question, consistent with the court's opinion on where you draw the line between an amendment of an old program and the creation of a new one. It appears to be sort of an I know it when I see it standard. Clearly, how Congress labels the program isn't dispositive, but that doesn't mean that the label is irrelevant. So if the legislation amends rather than displaces an existing law, you should say so. Further, the court did discuss some factors that, in its view, pointed toward the newness of the expansion. There was a difference in the funding, the federal matching grants, or FMAP, under the existing program and the expanded program, and that suggested to the court that the expanded program was new. It was funded in a different way. It sort of falls in the category of no good deed going unpunished. The court also said that the benefits were different under the existing program than they were under the expansion. Now, I don't think that's fully accurate, but to the extent feasible, you should try to harmonize the existing and the expanded program in terms of the features. To the extent that the new program can mirror the old one in funding and administrative structure in stated legislative purpose, where there really should be an effort to go to the original statement and try to readopt it in the legislative findings, or at least in the legislative history of the new statute. You minimize the risk of the court finding that the expansion or modification is a new law. Emphasize the consistency. Point to existing statutory provisions that are a source of the conditions that are imposed in connections with new amendments, if you can do that. Now, of course, a key factor here that led the court to find that this was a new program was the sheer magnitude of the expansion. And I recognize that insulation from hostile courts is not the primary goal of legislative reform, but from for the moment a purely parochial defensive legal perspective, incremental changes are likely to fare better in that particular regard than transformative ones. The other element of the equation on the Medicaid decision was coerciveness. What was it about the Medicaid expansion that coerced the states in a manner that was unconstitutional. And to me, it's sort of hard to wrap my head around the concept of coerciveness in this context, because states could have said no to the new program, and they could have given up existing Medicaid funding. If they did, they had that option. Their citizens wouldn't have liked it, and there could well have been a turbulent transition, though I think there's no doubt HHS would have not required an abrupt termination, but would have had an orderly transition. State taxes would have gone up, and the people might have voted their state leaders out of office. But is political palatability, feasibility, the measure of coercion for purposes of a constitutional analysis? And even if these political factors are a real world constraint, should the federal courts be taking these types of measurements? I think that's a significant question on how something less than a direct command by the federal government can constitute coercion. Nonetheless, whether or not the court is right on this issue, it is final. So the question is, what principles can you derive from the court's opinion to minimize the risk that a particular change will be deemed coercive? There are several, but first let me digress for just a moment and say that there is a real difference between coercion defined in the majority decision and coercion as defined in the dissent. The majority opinion focused on the amount of funding at risk if the state didn't comply with the conditions the Affordable Care Act imposed. The dissent suggested at one point that the attractiveness of the inducement to participate in a federal program might in itself render a particular piece of legislation coercive. And that is a new and somewhat extraordinary doctrine that had 4 votes. And we should all keep in mind that it had 4 votes, because it would be a fairly dramatic transformation of post-New Deal jurisprudence and a significant threat to post-New Deal, New Deal and post-New Deal legislation that is already on the books. With regard to the amount at risk, the court, as noted here, was influenced by the size and importance of Medicaid to the states. And so that suggests that when you are drafting or proposing legislation where the enforcement mechanism puts large established programs at risk, caution is particularly important. You should also be cognizant of the state's reliance interests. An enforcement mechanism that puts at risk a program on which the state and state employees have become dependent in some respect is more likely to be deemed coercive. Here you had a program that had been in place for 57 years. You had significant state bureaucracies that had been built up. You had a large segment of the population that was taking advantage of, if not dependent on the program. When you're dealing with this sort of program, particularly in the area of an entitlement program, that magnifies the risk that a condition that threatens the continuation of that program would be deemed coercive. in proposed legislation, you might expressly reserve the right to amend or repurpose the funding. Now, that wouldn't help you as to the existing legislation that you're proposing, but as to future changes to the particular program, it could dilute the argument regarding reliance. If you do have conditions that put funding at risk, you should be clear, if it's politically feasible or otherwise feasible, about precisely what is at risk. The fact in this case is that while HHS since 1965 has had the power to cut off all a state's Medicaid funding if it didn't comply with the mandate as to any part of the program, HHS had never taken such a step in 57 years of Medicaid's existence. Now, the threat may still have had value to HHS. The threat may still have exerted coercive force, but a tool that is unused for 57 years loses some credibility as a deterrent. And so it's entirely possible that the court, and in particular Justice Breyer, who asked questions along these lines during the oral argument, that the court may well have believed that by confining HHS's termination authority to the new program, it was merely ratifying existing practice. And if it is existing practice, as to the statute at issue or to the amendment at issue in the area in which you're dealing, the proposed legislation might as well accommodate that and delineate precisely what funding is at risk if the state does not comply. You should, in addition, invoke other sources of federal authority for a particular spending measure if there are other sources of federal authority. So one of those might be for discrimination provisions that exist in a lot of education funding, for example. Section 5 of the 14th Amendment could be a potential source of authority. Congress cited and was found a source of authority for the provisions cutting off funding to schools that discriminated against ROTC was the power of Congress to fund and form the military. And so that's a very significant power. So to the extent that there is something to supplement the spending power, that is useful potentially to cite as a source of authority in the decision or in the legislation or in the legislative history. Now, a cynic might say that none of this necessarily makes any difference, that in NFIB, the court, or at least some members of the court, were bound and determined to inflict some political blow on the statute, no matter what Congress did to insulate it from constitutional attack. Woody Allen once said that I used to be a cynic, but I couldn't keep up. But the alternative to cynicism is not resignation, but pragmatism. And so I want to leave you with some pragmatic points. First, and this is the overriding point, the NFIB decision does not have to, and really it should not, prevent advocates from achieving their regulatory or legislative objectives. Other things might prevent you from achieving your objectives, But those other things should be the focus of concern far more than the NFIB decision should be. Advocates are used to dealing with those other obstacles, and there is every reason to soldier on in that regard. Second, even though this decision may not pose the most formidable threat to your legislative and regulatory objectives, that doesn't mean it poses no threat. Prudence and pragmatism suggest that you should take steps to minimize the risks and, if nothing else, deprive opponents of constitutional ammunition or political ammunition using the constitutional arguments for political purposes. For example, you should avoid overt mandates if you can. After all, we generally managed without them for 193 years or so. Invoke the taxing power if feasible. And if you're resorting in a particular legislative proposal to cooperative federalism, rely more on the carrot than the stick, and design your program carefully to navigate the obstacle course that the NFIB decision has erected. Now, none of this is foolproof. If the partisan virus that has infected the legislature spreads among the judiciary, we have bigger problems, and they could overwhelm any and all of these measures. But I think there are grounds for optimism, and even if you disagree with me on the issue of optimism, there's still good reason to persevere. So if there are any questions, please submit them on the chat function, and I will be happy to address them.
Rob, while we're waiting for people to submit their questions online, I had a couple of questions that I wanted to pose for you. One was, you described that, or you explained how the court looked at the size of the Medicaid program and just like the sheer dollar amount that it provides to the states, and that was one of the factors that they used in sort of striking down the ACA's provision that would eliminate all of that funding for non-compliant states. Is there a risk, or what role would size play if you're talking about a much smaller dollar amount, but a program that provided either a near majority or a majority of a state's funding in a particular area? So the federal government sort of supplements the state's spending in a particular area to a great degree, even though the actual dollar amount is relatively small. Does that could that still possibly fall into the same traps that this Medicaid provision did?
Well, the court looked at the absolute amount, but it also discussed the percentage of the state budgets that Medicaid represented, that federal funding represented. So they were really talking about the overall state budget and the effect on the ability of states to make up that amount of money in taxes if they had not, if they didn't have the federal money. And so they were really looking at coercion writ large in terms of political, practical feasibility. That doesn't mean that a program that is important to a state but is much smaller would be free of any risk in this regard if the federal funding were a substantial part of that program. But it really is a risk of a lesser order than Medicaid was. Almost anything is a risk of a lesser order than Medicaid is.
The other question I had was that obviously in discussions of Medicaid, it's an entitlement, and a lot of other programs that some on the phone might be concerned with may not be entitlements and may be subject to reauthorization every 5 years. So when you're looking at sort of the question of whether or not a particular proposal is new or whether it's just an expansion of an old program, but you're looking at something that needs to be reauthorized every 5 years anyways. If you're dealing with the reauthorization, do you think that there would be more latitude to make more dramatic changes without raising sort of these constitutional concerns at that point, since at least theoretically the program would disappear entirely if the reauthorization wasn't undertaken? Do you think that makes a difference at all?
Yeah, it could, because one of the aspects that really influenced the court was the degree to which states were locked in to the Medicaid program. It had been on the books for 57 years, less for some states, but really it was entrenched. It was the principal way that states dealt with health care for their indigent populations, and that there was an expectation that it would continue. And so a program that comes up for renewal every 5 years would, I think, present less of an issue in that regard than Medicaid does. Now, I suppose it's possible that if the reauthorization was sufficiently perfunctory, the court might roll right over that issue. But I do think it strengthens the argument that about states having the option to not participate in the program. Mm-hmm. And it also strengthens the argument that that changes are expected and appropriate when the bill comes up for reauthorization in every 5 years or whatever the period is.
Yeah.
Well, if there are no other questions, I thank everyone for listening, and I hope this was helpful to you. I am happy to talk individually to anyone who has questions and would like to discuss how they affect particular legislative proposals or other initiatives. So thank you.